Good evening, ladies and gentlemen. Welcome to another in our series of public lectures on Indiana history in commemoration of the sesquicentennial of our state. And it occurs to me that it would be difficult to find a speaker in Indiana more qualified to speak to the subject. Our speaker is not only chairman of our Ball State Committee for the sesquicentennial celebration and a member of the county committee, I venture that our speaker has taught more college students Indiana history than any other man in this state. At least I'm willing to debate that point. He has produced a film strip, a set of film strips, that has been viewed with sufficient accolades by our state commission to have placed in every school of the state. He is an expert on Mr. George Nicholas, a colonial personality, and the colonial period as a whole. He is under contract to a publisher to write a textbook on Indiana history. I trust I have established his right to speak to you on the basis of his teaching experience and his scholarly activities. But it's difficult for me to introduce him because I think of myself and think of him in the relationships I've known for 16 years, rubbing elbows daily. And from those years, I can certify to you that he's not only an excellent scholar, but he's also an excellent gentleman. Dr. Richard Caldemeyer.
Thank you, Dr. Hannaford. Originally, I had intended to introduce myself because I'm always skeptical of these accolades and build-ups for fear I won't be able to deliver to the extent that they outline it. I'd like first to call your attention to, been asked to read this announcement in connection with the Delaware County Historical Society, which will hold their spring dinner meeting Thursday, April 28th at 6:30. And Mr. Kinsey tells me everyone is welcome. The topic will be their Hoosier Excellencies, which will be a continuation of Mr. Hawkins' address to this group last Wednesday. So you're welcome to attend that. Normally, talks on the constitutional questions are devastatingly dull. I regret to inform you that tonight's discourse offers little prospect of deviating from the norm. Anticipating just such a situation, I tried to do something about it. But despite my efforts to ferret out even the smallest bit of humor, none was forthcoming. After all, to inject levity on a serious topic like the Constitution is about like trying to make fun of motherhood. You just don't do it. Philip Wiley, to the contrary, notwithstanding. You will recall last week Mr. Hawkins apologized profusely for the frivolous nature of his talk. Perhaps Mr. Hawkins and I should have combined our talks. As indicated in the printed program, the title of tonight's paper is, Does Indiana Have a Horse and Buggy Constitution? Originally, I had entitled it simply, Indiana's Horse and Buggy Constitution. Then the thought occurred to me that such a title would imply that the purpose of this paper is to beat the drums for an immediate constitutional convention. Such is not the case. So by stating the title in the form of a question, I may be able to camouflage my own personal views on the matter. Hopefully, tonight I propose to accomplish 4 things in the brief time allotted me. 1, review the events which culminated in the Constitutional Convention of 1850. 2, point up significant contrast between the original and the present state constitution. 3, account for the many unsuccessful attempts to change our Constitution, and finally 4, present a few of the pros and cons on the question, does Indiana need a new Constitution? In attempting to accomplish these 4 objectives, perhaps the best place to begin is at the beginning, which in this case is the first Constitutional Convention. I need not remind you that this year we are celebrating the 150th birthday of our state. In fact, exactly 150 years ago yesterday, Congress passed the Enabling Act in response to Indiana's petition for statehood. Included in the provisions of this act was one which authorized the qualified voters of the Indiana Territory to elect representatives to a constitutional convention. It is not my intention to bore you with many details involving the staging of that convention. Instead, I shall confine my remarks to reviewing a few of the more significant aspects of that meeting and the document which emerged from it. First, it should be noted that our original Constitution was drawn up in an incredibly short period of time. Deliberations began June 10th and had ended June 29th. One reason the delegates were able to complete their assigned task in such a relatively short time was the fact that the Constitution they drew up was, in the final analysis, a fairly simple document. Consistent with the Jeffersonian tradition, it included provisions for many appointive offices on both the county and state levels, and gave broad powers to the legislative branch of the government. Parenthetically here, I might point out that in the years following the War of 1812, from 1814 to 1819, Indiana experienced its greatest growth in population, percentage-wise. The population of Indiana in the decade between 1810 and 1820 had increased 6-fold, and we sometimes refer to this phenomenon as the Great Migration, or simply the Jeffersonian migration. We use the latter term because the persons who participated in that migration carried with them the ideas and ideals of Thomas Jefferson. And included among these ideas was the belief in the least governed as the best way, and also the belief in an agrarian society. The idea here that people would come to know those persons best qualified to hold office, and they in effect would elect their betters, and this would carry out the Jeffersonian idea of government by the well-born. Typical of the belief in government by indirection is the fact that, having drawn up the state's first constitution, the convention submitted it to the federal government without first giving it to the people for their acceptance or rejection. For a number of years, Hoosiers seemed satisfied with their organic laws. In time, however, a more democratic spirit began to emerge on the frontier. Accompanying this new spirit was a desire for a more democratic constitution. Unfortunately, Indiana's first constitution provided for only one method of amendment, and that was by calling a convention. While such a provision was laudable in that it guaranteed periodic reappraisals of the fundamental law, it did serve to deny the people the right to make gradual constitutional changes. According to the provisions of the 1816 Constitution, the question of whether or not to have a convention was to be submitted to the electorate once every 12 years. The legislature interpreted this to mean that even though a referendum was mandatory every 12 years, there was nothing in the Constitution to prevent calling for a vote sooner. Operating on this premise, then, the Assembly held a referendum in 1822 or 23, at which time the voters rejected the idea by a large majority. In their centennial booklet on our present Constitution, Professors John D. Barnhart and Donald Carmody have indicated that one reason for the adverse vote was that some feared that the proponents of the referendum planned to change that part of the Constitution which prohibited slavery. You will recall that they tried to do this during the territorial period without success. Undoubtedly, there were other less obvious reasons. 12 years later, the question was resubmitted to the voters, and again it was rejected. In the general election of 1846, a third referendum was held. This time, over 32,000 voted in favor of a constitutional convention, while 27,000 opposed. Since the vote in the referendum was less than half of the number of votes cast in the general election held at the same time, the legislature chose not to view it as a clear mandate for a convention. For various reasons, pressure for a convention continued to mount. By the late 1848, Governor James Whitcomb felt the need to list several constitutional reforms and recommended the calling of a convention to revise or amend the fundamental law. His recommendations received favorable response in the Assembly. Accordingly, a referendum in which every qualified voter was eligible to participate was set for August 6, 1849. This time, the vote stood 81,000 in favor of the change and 57,000 opposed. Even though Governor Whitcomb suddenly resigned as governor to accept a seat in the United States Senate, his successor, Paris C. Dunning, carried out the proposal for a convention. Governor Dunning requested the legislature to designate the annual election in August 1850 as the time to select the delegates. In acceding to this request, the legislature went one step further and set October 7, 1850 as the opening date for the convention. They also stipulated in advance that the Constitution, when drawn up, would be submitted to the people for their acceptance or rejection. The Whigs suggested a bipartisan election of delegates, but the Democrats, who held a majority of seats in the Assembly, turned down the proposal. The confidence of the latter in their political strength was sustained when the voters gave them 2/3 of the 150 delegate seats. Before discussing specific features of the Constitution itself, perhaps a brief analysis of the reasons for calling the convention might be in order. First, it should be noted that in 1843 the Democrats had gained control of the legislature and retained it incidentally on through the early 1850s, in which Jeffersonian had given way before a rising tide of Jacksonianism. Naturally, the Democrats wanted to incorporate features of this newer and more dynamic philosophy in the state's basic charter. Specifically, they wanted to provide for the popular election of as many governmental officials as possible. Under the old Constitution, the Secretary of State, the Auditor, and the Treasurer, as well as other officials, were chosen by the legislature, while judges of the Supreme Court were chosen by the governor. The Democrats wanted these officers to be made elective. But it was more than philosophy that prompted the voters to demand a new constitution. By 1850, the volume of local and special legislation had become well nigh intolerable. Under the original constitution of the state, action by the General Assembly was needed to do such mundane chores as change names of individuals, grant divorces, that'd keep them plenty busy today alone, vacate alleys, incorporate local organizations, approve separate charters for railroads and industries, and enact special laws for the government of towns and counties. Under such a system, the demand for more and more special laws was bound to increase in direct ratio to the growing population of the state. As a result, log rolling was the order of the day in the legislature. The prevailing attitude of you scratch my back and I'll scratch yours unfortunately resulted in many undesirable concessions to local and special interests. In his message to the legislature in 1848, when he first urged the calling of a new constitutional convention, Governor Whitcomb used statistics to emphasize the dangers inherent in the trend toward spiraling special legislation. He pointed out that the numbers of general laws passed by the Assembly during the previous 5 years five-year period had remained fairly constant, while during the same period of time, the number of local and special laws had advanced 350%. In 1843, a total of 180 special laws were passed, but in the four succeeding years, this number had increased to 301, 365, 431, and finally 636, respectively. In view of this ever-increasing demand for special legislation, the time was rapidly approaching when the Assembly might meet in continuous sessions and still fall short of fulfilling the demands for such laws. Closely related to the increased ratio of special laws to general laws was the matter of economy, a factor not considered lightly by any frontier society. Many citizens viewed the annual legislative sessions as provided by the first Constitution as unnecessary financial burden on the taxpayers. The inability of the General Assembly to keep up with the demand for more and more special laws then meant that either more or lengthier sessions of the legislature would be needed. This, of course, was something which a growing number of citizens did not want. Furthermore, the internal improvement debacle of the 1830s and the 1840s had made the public critical of the Assembly. Since both political parties had been enthusiastic in their support of an overly ambitious internal improvement program, the public could hardly blame any one party. This left only the Assembly itself to serve as a scapegoat. In addition to these major sources of popular dissatisfaction with the legislature under the first Constitution, there were minor reasons for discontent. For example, many people objected to the mounting numbers of free Negroes coming into the state. Also, the failure of the General Assembly to establish an effective public school system was viewed by some as an inexcusable breach of promise. Finally, by 1850, more and more people had become interested in various reform measures ranging from property rights for women to a demand for greater financial support of the benevolent institutions which had been recently established in the state. It was against this background of discontent that the delegates to the state's second constitution began their deliberations. In contrast with the brevity of the first convention, this one lasted over 4 months. Also, as previously mentioned, it differed from the first convention in that its proposals were submitted to the electorate for ratification. Judging by the overwhelmingly favorable vote, the people apparently were sympathetic to the many changes included in the new Constitution. Hence, with and against the document, the elected representatives of the new General Assembly could begin their work with the satisfaction that they had a popular mandate to change. Recognizing that the new Constitution was designed to correct the weaknesses of the older document in a general way, there arises the question, specifically, what major changes were made. Since the legislative branch of government had been under sharp criticism prior to 1850, it was subjected to the most drastic changes. First, biennial sessions were substituted for annual sessions. Secondly, the new Constitution placed severe restrictions on local and special legislation. I might add here that while the Constitution tried to put severe restrictions and has succeeded to a large extent, we still find instances where these are necessary, particularly as regards municipal legislation. Wherever feasible, the Constitution provided for a system of general laws. Also, it stipulated that no law could embrace more than one topic, and that the subject of each bill had to be clearly stated in its title. This was designed primarily to prevent omnibus bills. In keeping with the Jacksonian tradition, more offices were made elective under the new Constitution. All judges and prosecuting attorneys, as well as most of the other county officers, were to be elected directly by the voters. Now, on the state level, the Secretary of State, the Treasurer, and the Auditor were to be elected, and their terms were reduced from 4 to 2 years. Again, we see the Jacksonian influence. Jackson favored rotation in office, except when it came to his own re-election in 1832. Although the powers of the governor remained virtually unchanged, his tenure was limited to 4 years in any period of 8. In the area of public education, significant changes also were made. While the original Constitution had been most generous in promising, quote, a general system of education ascending in regular gradation from township schools to state university, wherein tuition shall be greatest, from township schools, tuition shall be greatest and equally open to all, unquote. Unfortunately, it contained the qualifying clause, as soon as circumstances permit. Thanks to the dedicated efforts of Caleb Mills, Robert Dale Owen, and others, the 1851 Constitution not only made it mandatory for the General Assembly to provide by law for general and uniform system of common schools, but it spelled out the sources for their financial support. The fact that the new Constitution was silent on the subject of secondary and higher education evoked some protest. But since the vast majority of the young people of that period were not prepared to take advantage of higher education, such protests were kept to a minimum. There was considerable anti-Negro sentiment among the people of Indiana on the eve of the Civil War. This hostility towards the Negro was reflected in Article 13 of the 1851 Constitution, which prohibited the entry of any Negro or mulatto into the state, and which stipulated that all contracts made with any Negro or mulatto coming into the state contrary to this provision would be void. Furthermore, any person who was convicted of employing such a person or encouraging him to remain in the state would be subject to a fine of not less than 10 nor more than $500. This ought to be a good springboard for my talk 2 weeks from tonight on the Ku Klux Klan. While most of the early Indiana settlers opposed slavery, it did not follow that they were pro-Negro in sentiment. The fact of the matter was that they disliked everything about slavery, including the Negro himself. Some feared that Indiana might become a dumping ground for the aged and infirm Negroes of the South, while others felt that the mere integration of races was morally wrong. It was not surprising then that when this article was submitted to the voters separately in 1851, it was adopted by an appreciably greater margin than was the Constitution itself. That portion of the Constitution which has occasioned the greatest discontent over the years is Article 16, which outlined the process of amendment. According to its terms, all proposed amendments must be approved by both houses of two successive sessions of the Assembly and then by the electorate. Even though this method of amendment has made it extremely difficult to change the Constitution, in one way it marked an improvement over the earlier one, which included no plan for amendments short of calling a convention. Unlike the original charter, our present one does not designate a referendum for a constitutional convention. Even so, the possibility of staging such a convention is not precluded, since the Bill of Rights suggests that this power is inherent in the electorate. Although the Constitution of 1851 was ratified by a comfortable margin and seemed to conform to the spirit of the period in which it was written, its basic inflexibility has elicited many protests over the years. Some have argued, what good is an inherent right unless you can exercise it with some degree of convenience? Even a casual reading of the history of our state reveals that the difficulties that have been encountered in attempts to amend the Constitution are numerous. Out of more than 450 amendments that have been proposed, only 20 have met the rigid requirements necessary for adoption. And I might add that out of that 20, 10 of those have come since 1932, which proportionally would be a much larger number. The first change in our present Constitution was made in 1873, when an amendment was adopted prohibiting any further liability in connection with the debt settlement growing out of our internal improvement debacle of the 1830s. There is a lot of talk about the repudiation, or so-called repudiation, by Indiana of its internal improvement debt. And by strict interpretation, we did not repudiate it, simply because we did not unilaterally refuse to pay for the bonds and the interest on the bonds. But what we did do was guarantee only half the payment, then called in the bondholders and said, you can have, we're not going to pay the other half, you can have the canal, which they didn't want. But so in effect it was, in spirit, perhaps a repudiation or a partial repudiation. 8 years later, that is 1870, 7 additional amendments were approved by the voters in a special referendum. 4 of these pertained to Negroes and were designed to bring the state's constitution into harmony with the 13th, 14th, 15th Amendment of the federal Constitution. One of these omitted the word white from suffrage requirement and added further residence requirements. Another eliminated that section of the Constitution which denied suffrage to the Negro. A third stipulated that Negroes should be counted in state enumerations and in the apportionment of representation. And a fourth substituted an article which limited the debts of municipal corporations for Article 13, which had excluded Negroes from entering the state. The remaining 3 amendments are less important. One changed the date of general elections from October to November. The other one authorized the grading of local offices in order to legalize differences in salary. And a third changed the wording of one of the judicial provisions so as we could get a appellate and a superior court. All 7 of these early proposed changes were approved by the legislatures of 1877 and 1879, as required by the Constitution, before they were submitted to the voters in the general election in the spring of 1880. Here they were approved by a majority of the voters who voted on the amendments in that election, but they failed to obtain a majority of all the votes cast in the general election proper. Even though the Supreme Court, in the case of, and I've written these cases on the board, even though the Supreme Court, in the case of State versus Swift, ruled that amendments, that these particular amendments had not been adopted, it held also that neither had they been rejected and therefore might be resubmitted. It took a special referendum in 1881 to get these proposed amendments ratified. And the whole history of the amending process is that, first of all, if you have a special referendum in which the people only vote on this one issue, then the likelihood of passage are good. And secondly, if it involves the federal constitution, there was always a tendency to try to bring these into conformity with the federal constitution. Following these initial attempts to amend the fundamental law of Indiana, the courts took an increasingly dim view of constitutional changes. One of the most significant cases to reach the Indiana Supreme Court was the case commonly referred to as the Lawyers' Amendment, which authorized the General Assembly to prescribe more stringent qualifications for those persons practicing law within the state. Before that, all you had to have is a good moral character and pass an examination. This proposed amendment received the approval of both houses of the legislature, one in 1897 and again in 1899, and was submitted to the voters in the general election in the fall of 1900. But it was the same old story. In a case known as In re Denny, the Supreme Court ruled that this proposal was rejected since it had not been approved by a majority of the voters who had cast ballots in the general election. It was resubmitted to the voters in 1906 and again in 1910 with the same results. In a case known as Henry Boswell, the court reaffirmed its earlier decision. By 1911, it had become apparent that constitutional amendments stood very little chance of ratification unless they were submitted to the voters in a special election. Since this was both an awkward and an expensive procedure, Governor Thomas Marshall urged the legislature to draw up an entirely new constitution and submit it to the people for their approval. Even though the General Assembly acted favorably on this suggestion, the Supreme Court, in a case known as Ellingham versus Dye, ruled that the legislature had exceeded its authority in drawing up a new constitution, and added that if the proposed constitution was to be considered to be a series of amendments, the prescribed constitutional procedure had been violated. Despite the feelings of frustration occasioned by these adverse court decisions, the legislators continued their attempts to alter the state's charter. Such persistence can be explained partially by noting the fact that at this particular time in history, a wave of progressivism had engulfed the Middle West and had popularized the idea of constitutional reform. In keeping with this progressive movement, the Assembly in 1913 passed 22 amendments which embodied the main provisions of the ill-fated Marshall Constitution. Since they were introduced by Senator Evan B. Stotzenberg of New Albany, they have come to be known as the Stotzenberg Amendments. After voting favorably on these amendments, the General Assembly submitted them to the voters along with a call for a constitutional convention. The optimism which attended the acceptance of these proposals by the Assembly in 1913 gave way to gloom in the 2 years that followed. First, in 1914, the voters disapproved of the proposal for a constitutional amendment. And then in 1915, the Assembly rejected the Stotzenberg amendments which had been passed in the previous session. With the election of a new legislature, hope for constitutional changes was renewed. You can say one thing, they never said die. In 1917, the Assembly acted favorably upon Governor Goodrich's suggestion that a new constitution, or new constitutional convention be convened. But alas, even before the delegates could be elected, the measure was brought before the Supreme Court, which declared the act unconstitutional on the ground that the question of such a convention had not been previously submitted to the voters. Failing in its second attempt to get a constitutional convention, the legislators revived the tactics used in connection with the Stauffenberg Amendment earlier. In 1919, they passed 16 amendments, 13 of which were sustained by the legislature in 1921. Even though these amendments, these 13 amendments now, were submitted to the voters at a special election in 1921, only the one extending the franchise to women was ratified. Apparently, the reaction which had set in following World War I was strong enough to defeat the proposed changes. As in the case of the Negro Amendment following the Civil War, the Woman Suffrage Amendment was accepted so as to bring the state constitution into conformity with the federal constitution. In retrospect, one cannot help but admire the persistence of the reform members of the General Assembly during this period. In 1923, they renewed their efforts to amend the Constitution. Again, they were successful in getting the approval of 2 successive assemblies, but again their handiwork was rejected by the voters in a general election. In 1927, 2 more amendments were approved by the General Assembly. One permitted the levying of a state income tax, and the other revived the oft-tried lawyers' amendment. Although the succeeding legislature sustained the earlier legislative approval, the proposal received the same treatment accorded previous amendments in the referendum. When submitted to the voters in the general election of 1932, a majority of voters reacting to the amendments was favorable, but still the count fell short of the required majority of the votes cast in the general election. There is an old saying, "It is always the darkest before the dawn." Certainly, the failure of the lawyers' amendment in 1932 was a dark hour. Indeed, for the progressives who sought to change the Constitution of Indiana were unable to do so. But then came the light. Not just a ray, but a veritable flood of light. In a case known as In Re Todd, the Supreme Court reversed its previous rulings and held that a majority of those who voted on a particular amendment was sufficient for ratification, even though such a vote did not constitute a majority of the votes cast in the general election. You know, I'm getting tired of that clause. I tried to screen this paper and delete those, but whenever I did, I distorted the meaning, so I had to keep it in there. I think that's the 6th time that's appeared in here. Although this decision did resolve one thorny issue, it simultaneously raised a new one. Was it to be retroactive? If the answer was yes, then the earlier amendment proposals which had received a majority of the votes cast for the amendments themselves would now be considered a part of the Constitution. For 13 long years, this question went unanswered. Finally, in 1948, in a case known as Oscar Swank et al. And Robert H. Tyndall, the court ruled that the decision in Re Todd applied only to those amendments submitted in 1932 and to those submitted after that date. Long overdue, this decision cleared the air at least and gave renewed hope to those planning to propose new amendments. Meanwhile, the easing of the ratification requirements, as set forth in Re Todd, permitted the passage of 5 new amendments. In 1936, Article 12, Section 1 of the Constitution was changed to admit Negroes to the state militia. In 1940, 3 additional amendments were ratified. One repealed the double liability of stockholders of banks. Another repealed the 20-year limit on bank charters. And a third transferred the liabilities for obligations of corporations from the corporators to the stockholders. In 1948, a constitutional amendment was passed and ratified which increased the term of county sheriffs to 4 years. Since that date, 1948, the following 4 amendments have been added. 2 in 1952 dealt with the terms of office of certain county officials, and in 1960, one amendment set the qualifications for circuit court judges, and another directed that all bills before the General Assembly carry simplified titles. Currently, 2 amendments are pending, having passed the 1965 General Assembly. One would amend Section 1 of Article 10 of the Constitution by permitting the General Assembly to exempt certain property from the property tax. The other proposed amendment, which is pending, has the potential of effecting a most significant change in the Constitution. It would amend Section 2, Article 16, by removing certain restrictions with reference to amending the Indiana Constitution. If this measure is passed by the next General Assembly and subsequently ratified by the voters, additional amendments can be entertained by the Assembly, even though final action has not been taken on those amendments already pending. This could be a truly significant milestone in the amending process. Thus far, then, we have seen that ever since the turn of the century, there have been strong movements urging a new constitution for the state of Indiana. Despite the failure of the earlier attempts, which we have already noted, to bring about such a convention, various groups continue their efforts in that direction. The arguments advanced in support of such a convention are as varied as they are numerous. Now, in the next 5 minutes, I would like to list a few of the arguments that have been advanced in favor of a constitutional convention, or at least in favor of constitutional change. And I want to do this without any attempts at priority, simply to enumerate the arguments and the counter-arguments. One, of course, is the ubiquitous question of apportionment. Some argue that even though we have a 2-house legislature, the basis for apportionment is the same for both houses, that is, population. One group that objects to our present apportionment plan would have population as the basis for representation in the House of Representatives and geography the basis for determining the selection of senators. Another group is equally insistent upon changing the apportionment pattern, but think that the problem can best be solved by having a unicameral instead of the traditional bicameral legislature. Since any change in apportionment would most likely diminish the representation of rural areas, most of the people residing in those areas are understandably opposed to most reapportionment proposals. A second point of contention is on the matter of re-election of the governor. Those who favor the Constitution to allow the governor to succeed himself point out that by following the present Constitution, the governor is a lame duck the day he takes office. They feel that this not only denies the voters a free choice in the selection of the next chief executive, but that it causes the incumbent governor to lose control of the party. Furthermore, they contend the present system prevents the administration from embarking upon any long-range program. But then on the other hand, there are those who see a real danger in a longer tenure for the governor. They feel that if his tenure were extended, he might use his executive powers to perpetuate both himself and his party in office. 3, abolition of the justices of peace and township trustees. I hope there are none here tonight. Here the argument is advanced that our modern age no longer requires the services of such officials. There are some, however, who favor retention of the justices of the peace on grounds that these officials expedite justice involving certain misdemeanors. While some of the latter group may admit that in certain instances the caliber of these officials leaves something to be desired, they feel that this deficiency could be resolved by imposing higher qualifications for candidates for this office. The arguments in favor of retention of the township trustees are more difficult to defend, since many of the duties of this office have been assumed by other agencies. At one time in the history of our state, the township trustees had the responsibility of administering the educational system of the township. Today, the trend is toward consolidated schools, which elect their own school boards. Moreover, such matters as poor relief, roads, and property assessment increasingly are handled by other agencies or by other means. A fourth argument in favor of a constitutional change or revision concerns the selection of certain state officials, such as the State Superintendent of Public Instruction, the Attorney General, the Treasurer, and the Auditor. Many feel that because these officials are popularly elected, it makes political savvy the principal qualification for such an office. They argue that by raising professional requirements for these positions and by making them appointed, better government could be achieved. At least such a move, of course, would help centralize the administrative responsibility. It's rather interesting here to see how we complete the cycle. We start out with the first Constitution with the Jeffersonian concept of more appointive offices. We go into the Jacksonian belief in elected offices. Now we're back where we started from, at least in the minds of some people, to have more appointive offices. 5, many city officials cite the need for constitutional changes which would permit a greater degree of home rule for cities. According to Dillon's rule, and I just learned this yesterday, so you'll excuse if I don't show the greatest comprehension. According to Dillon's rule, the cities and municipal organizations have no power other than that which has been delegated or clearly implied by the Constitution or by the legislature. Recognizing the validity of this rule, those advocates of constitutional change in this area want a constitution which will provide for the granting of municipal charters so that cities can do all things relating to city government not specifically denied them in the charter. When you think that over, you can see there's a very basic difference here. It's like asking your parents for permission to do something. They say no, and if you go ahead and do it, then if you do it wrong, they can't punish you too much. Under our present Constitution, for example, such progressive moves as a city manager plan are not permitted. It is no surprise then that the Indiana Municipal League currently is one of the most articulate groups actively engaged in studying the possibility of a new constitutional convention. Naturally, there are other groups opposed to these maneuvers. One could hardly expect the farmers of Indiana to be sympathetic to the demands of the Municipal League for a convention. 6, there are some people who want to return to that provision of Indiana's first Constitution, which made it automatic for the question of a convention to be submitted to the people in a referendum at regular intervals. Opponents of this proposal have been quick to point out the right to alter the Constitution either partially or completely is already guaranteed in Article 1, Section 1 of our present Constitution. Finally, by way of examples on the pros and cons on the issue of constitutional change, there are those persons who feel that a new Constitution is needed to eliminate those provisions which are obsolete. This argument is countered with the reminder that such obsolete provisions can either be quietly ignored or can be removed by the usual amendment procedure. Now, as I say, these are highly selective. I made no attempt at priority. I could enumerate many other items, and I'm not going to discuss them. One is there are people thinks that the Constitution ought to give the governor an item veto of certain bills. Another would reconsider the no debt policy. Our economists, I think, would in general support at least a revision of the no debt policy. We have a no debt restriction, and then we proceed to wink at it. In the case of the bonds, I think for the toll road, they have winked at it. In connection with the building of the state office building, the private groups formed, as I understand it, sort of a holding company. They have an agreement with the state. The funds are subscribed privately. The state rents the building, and then when their rent payments plus the interest is enough to pay for the building, then title is given. Well, that is simply another way to, of course, bypass the no debt restriction. And then there is some question, and increasingly this is a point, that they think that Indiana ought to entertain suits of tort. Now, I had this explained to me too. For example, in the case of the recent Coliseum disaster, in which 74 persons were killed in that blast on Halloween 1963, the state of Indiana can be sued only with its permission. And here the argument is that in some cases the state should be held liable. And if we would have to change our Constitution to do it. That if they could prove that officials of the state, for instance the state fire marshal, are at fault, then they should be permitted for compensation. And even as it now stands, any compensatory law would in effect be special legislation, the very thing our current Constitution tries to do without. And then I might finally mention a recent case of a person who had been tried and convicted for a crime, and after spending 17 years in the state penitentiary, the real slayer was apprehended. Under our present system, the aggrieved person has no recourse except as to what the state wants to do. It has not been my intention tonight to attempt any exhaustive listing of arguments on the question of constitutional change. The few examples I have cited are simply typical of the many diverse views which have been advanced in this controversial area. Furthermore, it is not my aim to debate the issues here tonight. I shall conclude this brief historical review of constitution making in Indiana by accentuating the positive. It must be recognized that even though many disappointments have attended earlier attempts at constitutional change in Indiana, certain factors point to a brighter future. As previously mentioned, the Supreme Court decision in the celebrated case of Henry Todd has permitted constitutional changes which would have been impossible, or which had been impossible, from 1851 to 1932. Furthermore, if the next session of the General Assembly concurs in the decision to remove certain restrictions with reference to amending Indiana's Constitution, and if a majority of the voters will support this proposal in a referendum, another bottleneck will have been removed in the amending procedure. Today we stand at the crossroads as regards constitutional reform. The recent enlightened view of court decisions undoubtedly will increase the tempo of basic changes in our present Constitution. This trend may mollify those groups who have been most insistent in their demands for a new Constitution. If this does not occur, or if the present trend of a more sympathetic court decision reverses itself, there is still time and there are still ways to achieve the elusive goal of a constitutional convention in Indiana. Thank you.